All right, it is 8:10 a.m., June 21st, 2024. I'd like to go ahead and call the full board to order. Can we have roll call, please?
Yes. Good morning, everyone. There we go. Now my camera's on. All right, Dr. Zaffron.
Present.
Dr. Farmer. Mr. Kokonos. Mrs. Barnes.
Present.
Dr. Bhatia.
Present.
Dr. Deloche.
Present.
Dr. DeStefano.
Present.
Mr. Gracia. Mrs. Herod.
Here.
Dr. Martinez.
Here.
Mrs. Morgan.
Here.
Dr. Naidu.
Here.
Dr. Nyack.
Present.
Dr. Quinones.
Present.
Dr. Tibbles.
Present.
Dr. Vanderwide.
Yes, sir.
Okay, I count 13 present, so you do have a quorum and may proceed.
Thank you, Mr. Carlton. As always, at the beginning of every board meeting, we always read our mission statement. Our mission is to protect and enhance the public's health, safety, and welfare by establishing and maintaining standards of excellence used in regulating the practice of medicine and ensuring quality health care for the citizens of Texas through licensure, discipline, and education. The first item on the agenda is our board member report. There's a couple of things that I will highlight. The Federation of State Medical Boards typically, of course, has its annual meeting. There's a couple of items that myself and Mr. Carlton and Mr. Palazola, and as well as members from the PHP who attend the FSMB, and we provide input from the Texas Medical Board along with other boards around the country as to things that are important, as well as take back from the Federation things that are important that are going to be coming down the pipeline that we would be looking at and addressing for our licensees. The three things that I would like to highlight that are of importance is number one, artificial intelligence. In the medical community, there's a large push to actually call it augmented intelligence because we would like to look at it as augmenting physician judgment as opposed to replacing it. We would never seek to have AI replace physician judgment in maintaining and treating a patient, but it would be more of an additive type of structure. But as such, it is something that is moving very fast and very quickly. The technology is moving at breathtaking speed, and we want to make sure from the regulatory side of things that we also stay ahead of it. So as such, we are always going to be looking at our rules, our standard of care, how it applies as AI becomes a larger component and part of our practice. It's not exactly like EMR, but to an extent where a lot of physicians feel like EMR moved forward and the rules and regulations around electronic medical records kind of followed afterwards and created a lot of frustration. In this instance, we want to make sure that we're ahead of the technology, that we're not responding to what's out there, that we actually put our rules and regulations out there and ask industry to kind of follow along with what those rules are. So a lot more will be coming on that. There's also obviously a lot of discussion. There's a lot of stakeholders that are involved with this, but it is something that we will be constantly making sure that we address. The other thing that has come up and is always an issue that is important for us is physician wellness. Physician wellness is one thing that, of course, is addressed by the PHP, which is a separate entity, but underneath the medical board. It acts with a firewall so that those who are managed and helped under the PHP are separated from the medical board unless they have any type of oversight or disciplinary action from the medical board. But physician wellness is something that we pay a lot of attention to. We have mechanisms and structures in place so that physicians who feel the need to get help, that they can do so without fear of losing their license. But that does mean, of course, seeking help in the appropriate manner and in a way that allows them to get that proper help, to make sure that they are well enough to be able to manage and treat patients, and to do so in a safe manner. Obviously things like burnout, the regulatory burdens that are out there all add into issues around physician wellness. And again, it's something that I just always like to emphasize to our licensees. If you need help, please seek help, and do it early on, not very much later in the process. But one of the things that we also notice as a board, especially as we receive complaints from patients, is that there's a common theme, and I think that is probably somewhat related to the whole burnout issue and the frustration around the regulatory burdens that are out there. And that is the lack of, or the perception of the lack of communication, or even maybe empathy between physicians and patients. And I want to really emphasize that, as physicians, we all have a calling to do no harm, of course, but to also treat our patients with the utmost amount of respect. And it is important that part of that process is good communication, and maintaining that level of trust between physicians and patients in that sacred physician-patient relationship. It is something, like I said, that we've seen fairly commonly, and there's probably a multitude of reasons why it happens, but I just want to emphasize that it is something to really pay attention to. Good communication and empathy can go a long way in preventing harm, but also in preventing complaints to the medical board. Most patients who complain to us, when we actually sit down and talk with them, the most common thing that I hear from them is that they didn't feel like they were being heard. And that's a real thing, and that's a real perception. And remember, that perception becomes reality. So it is something that I really hope our licensees pay particularly more attention to. It's important, and I know most of you do that, but it doesn't hurt for all of us to be reminded that this plays a large role in making sure that our patients feel well and they feel like they're being managed and treated, especially in very vulnerable times of their life when they're sick. The other thing that I was going to bring up and mention is our CE broker, which is something that we rolled out for physicians specifically on June 1st. I think the initial feedback that I'm getting is that it's going well. For our licensees, it's a way for them to track their CMEs. For us, it's a way for us to more easily and in more real-time audit that the CMEs are being done properly and appropriately. Again, I want to emphasize that this is a free service for both our licensees and for the medical board. There are premium options that a physician or a licensee in general may opt to sign into if they choose, but that's not something that the board requires. What the board requires as far as CME credits is something that we use CE as a tool to be able to help provide for us. And the last thing I'll mention as part of my report is something about med spas that I had mentioned in my newsletters in the past. As I had mentioned in the past, our med spas that are out there, we want to make sure that they are following the appropriate rules and regulations as far as establishing proper physician-patient relationships in managing and treating patients who go through med spas or hydration clinics or whatever they might be. One of the things that we have learned from other states and what they have done is that as this is proliferating and providing a service that is new and unique, it is important for us to make sure that the rules and regulations around it are followed, but that it does take multiple agencies in helping manage that process. So one of the things that I'm going to be asking our staff to do is to put together an ad hoc committee. Our board has already approved that, but it will also involve communication and coordination with the pharmacy board, the nursing board, now the PA board, which is under the medical board also, and for all of us to act in a coordinated fashion in making sure that our rules and regulations are being followed properly. These are all boards that have, to a certain extent, oversight over what happens in med spas. The pharmacy board with the prescribing or the dispensing of medications in med spas. Nurse practitioners and PAs when they have prescriptive authority and they're managing and treating patients also in med spas, as well as, of course, the medical board itself. There's also concerns about providers or practitioners who don't have proper authority also providing care in med spas. And as such, we are going to look at revamping our mechanisms of how we file complaints or allow folks to file complaints when it's not a licensed provider that is providing care at one of these facilities. So more to come on that. But again, it is a service that is being provided for patients or for citizens out there, and we just want to make sure that it is done in a way that maintains that level of safety for all of our patients. So that is my report, and there will be more to come on all that in the following newsletters in the following months. With that, our next agenda item is number 3, consideration and possible action for dispositions below minimum guidelines. There's one item there, and this is an item that we need to have a motion on, but is there any extractions or recusals on this agenda item? Seeing none, is there a motion on agenda item number 3?
Motion to Stefano.
What's the motion? What's the motion?
Make a motion to accept item number 3.
Okay, so a motion to accept action for dispositions below minimum guidelines. There was a second.
Vanderwide.
Dr. Vanderwide, is there any discussion? All right, seeing none, all those in favor, please say aye.
Aye.
All opposed? All right, agenda item number 3 passes. Agenda item number 4, consideration and approval of mediated settlement agreed orders. There are 2 items under there. Are there any extractions or recusals? All right, seeing none, is there a motion on agenda item number 4?
Quinones, motion to accept the consideration and approval of mediated settlement agreed orders.
Second, Dr. Knight.
So seconded by Dr. Vanderwide. Is there any discussion? All those in favor of agenda item number 4, please say aye.
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 All those opposed? All right, agenda item number 4 passes. Agenda item number 5, and there are multiple items under agenda item number 5. Consideration and possible action for remedial plans, administrative rules, crime laws, there are none, impairment, none, peer review status action, state action, standard of care, unprofessional conduct, and late remedial plans. Are there any extractions or recusals on agenda item number 5?
I'd like to pull item 3.
Okay, we are pulling agenda item
Correct.
number 3 under, sorry, agenda, or number 3 under agenda item number 5. Anything else? All right, with that, with the exception of item number 3, is there a motion on the rest of the items under agenda number 5?
I make a motion, Dr. Naik, to accept agenda item number 5.
With the exception of item number 3. Is there a second?
Barnes, second.
All right, is there any further discussion on the rest of the items under agenda item number 5?
I thought it was number 4. Sorry, Dr. Zafran. Are we on 4 or 5?
5.
5.
Five.
Oh, you know what? Okay, got it.
Yeah.
Okay,
All
thank
right.
you.
It's all right. Any discussion on agenda item number 5? All right, with the exception of item number 3, all those in favor, please say aye.
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 All those opposed? All right, agenda item number 5 passes except for item number 3. Ms. Morgan, do you want to speak to item number 3?
Yeah, we probably need to go into executive session on it.
Okay, do you want to make a motion to go into executive session?
Okay, yeah, I'll make a motion to go into executive session to discuss item number 3.
Second, Barnes.
For the purpose of advice of counsel? Okay, I'll go ahead and read the statement. Okay, so a motion's been made to go into executive session to discuss and for private consultation under advice of counsel. It has been moved. Is there any objection? Seeing none, this meeting is now closed to the public at 8:24 a.m. on June 21st, 2024. The meeting will continue in executive session for the purpose of private consultation and advice of counsel concerning pending or contemplated litigation, settlement offers, and/or legal matters subject to the attorney-client privilege under the authority of the Open Meetings Act, Section 551.071. While in executive session, the board will not take any action, make any decision, or vote with regard to any matter that may be considered or discussed. What we did last time, because this is a little bit different, is typically speaking, we kick everybody out. We're not going to do that. We are actually going to go into a separate room and discuss this item under executive session, and then we will come back out from executive session and then discuss this item in open public meeting after that. All right?
Yes,
So are
and
we in executive
so-
session?
No, not yet. We all need to get moved over to the breakout room. So give us a moment, and Anne Marie is going to facilitate that. Anne Marie, let me know what I can do to help.
Thank you, Ms. Pajak. I'm going to go ahead and open the breakout room. Once you all have arrived in the breakout room, I'll need your help to make sure everyone you want is in there. One moment.
Thank you so much. Sure.
All right, everyone. We're going to go ahead and come back into a normal session. It is 8:59 a.m. on June 21st, 2024. There was no final action, decision, or vote with regard to any matter considered or discussed in executive session. A certified agenda of the executive session was made. So going back to agenda item number 5, item number 3, and I'm just going to reiterate that there are, from what I understand, a recusal from Dr. Bhatia on this case, and there's also a recusal from myself on this case. So neither he or I will actually vote on this specific item.
Dr. Zafran, I'm sorry
yeah.
to interrupt. Can you give us a second? Make sure all of the board members' mics and cameras are enabled, so when there is a vote, they can participate. I'm getting messages that some of them are not. Ms. Barnes, trying to make her mic, so just give me a second. I'm sorry, before you call for a vote,
okay.
but you can keep talking. Okay, thanks.
I
I think
don't,
about just need
I
to
don't
cycle
think I'm
their
in the meeting.
camera and mics.
I don't think I'm in the meeting. Hello?
You are. We can hear you.
You are. We
Oh,
can
I
hear you.
I can't see anyone.
Yeah,
We
it's probably
can
just
see
taking
you.
a second.
You're like a little blue dot.
I don't see Scott. Let's see. He says his camera
Yeah,
and mic are disabled. We got to get Scott fixed.
If all the board members can try to click their camera and mics just to cycle them to get them back on. I had to do that for mine as well. And while we're doing that and waiting for them to come on, just to add to what Dr. Zafran was saying as far as the recusal, to also want to make sure for everyone that that neither Dr. Zafran nor Dr. Bhatia, because we're talking about a recusal, had any part of any of a discussion during that executive session either. So, so just so the public is aware, when someone does recuse, not only are they recusing themselves from the vote on the item, they are recused from any discussion on the item as well.
I can only see myself.
It's okay, Luann. We can see you. So, you know, so you're visible to all of us over here. So it's okay. Brent, why don't you go ahead and actually call the vote on this item?
Let me again make sure all of the board members have popped up again. But yes, I will call the vote for it since you're recusing.
I don't know if Sharon Barnes is on.
She is.
Is she?
I'm here. Thank you,
Okay.
Louis.
1, 2, 3, 4, 5, 6, 7, 8, 9.
Yeah, I'm also counting 8 board members, 9 board members visible. Or at least that can be on camera. I know Dr. Tibbles is in there with you, Dr. Zafran.
Okay, Sarah and Wendy, Kamisha,
yeah,
do we have 10? I think we
Is-
do.
Is
even though
Dr.
Brent-
Martinez?
Yes.
Is Dr. Martinez on? I don't see Dr. Martinez.
So
Because
I do
Dr.
see
Bhatia-
10, but I think I agree that I don't see Dr. Martinez, but I do see 10 members.
Even with Dr. Bhatia and Dr. Zafran recusing, they can form part of the quorum. They just won't be voting. So if we can get that minimum of 10, Brent and Dr. Zafran, you can proceed.
Oh, there we go.
If you want
There's
to, or
Dr.
we can
Martinez.
wait to try to get your other couple of members.
Dr. Martinez is on right now.
Yes.
Okay, good.
Martinez did join.
Right.
And it would be good to be able to see Dr. Tibbles at some point as well on the camera, but yes, we're good.
Yeah, I know he's there with you,
Thank-
Dr. Zafran. So that's 11 I count. Is that
He's
what
sitting
you
right
count?
next to me.
I'm here.
Yes.
Maybe if I
Here we go.
talk, that'll change
There,
the view.
perfect. Panning
There we
out.
go,
That's
Steve.
great. Perfect.
All right, we do have enough now to continue on with the vote. And so again, to help out here, since Dr. Zafran is recused from this, I'll go ahead and call the vote for you. Go ahead, Dr. Quinones.
This is Dr. Quinones. I make a motion that we accept the remedial plan as considered for under section 5, item 3.
All right, so we have a motion to accept the remedial plan as presented for agenda item 5, number 3. Is there a second?
Second, Dr. Martinez.
All right, there is a second on the motion. Is there any further discussion? Okay, all in favor, please say aye.
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 I'll abstain.
Okay, any opposed?
Nay.
Opposed, nay.
Abstain, Dr. Naidu.
Okay, I think if we have 10 voting, we had what, 7 that are in favor, 2 against, and 1 abstaining, and 2 recusals. I think I have those numbers right. Scott, if your team wants to double check me on that, but that is enough to pass the item.
Yes, and I do believe that was accurate on that, Brent.
Okay. An unusual one for the board, I understand, but again, it's important that we get the count correct. So thank you all, and I will turn it back over to Dr. Zafran.
Thank you, Brent. All right, moving on to agenda item number 6, consideration and possible action for agreed orders. Under that, we have administrative rules, crime laws, impairment, peer review, state action, standard of care, unprofessional conduct, and late agreed orders. Are there any extractions or recusals for agenda item number 6?
Dr.
Seeing none-
Deloach, I'd like to,
Sorry, go ahead, Dr. Deloach.
under item number 6, the number 19, I'd like to recuse myself, please.
Okay. Any others? All right, with that, is there a motion on agenda item number 6?
A motion to accept item number 6, consideration and possible action for agreed orders. DeStefano.
Second, Vanderwide.
Okay, we have a motion and a second. Is there any further discussion? All right, with the exception of Dr. Deloach for item number 19, all those in favor, please say aye.
Aye.
All those opposed? Agenda item number 6 passes. Number 7, consideration and approval of modification request, termination request orders. Are there any extractions or recusals on agenda item number 7?
This is Dr. Robert Martinez. I'd like to recuse myself from number 4, Galindo.
Okay. All right, with that, is there a motion on agenda item number 7?
Motion made,
Vanderwide,
Dr.
move to
Naidu.
approve.
Okay, motion made by Dr. Vanderwide. Was there a second?
Second, Naidu.
Second by Naidu. Is there any further discussion on agenda item number 7? All right, with the exception of item number 4, that's Dr. Martinez is recused in. All those in favor, please say aye.
Aye.
All those opposed? Agenda item number 7 passes. Number 8, consideration approval of modification request, termination request of non-public rehabilitation orders. There are none there. Number 9, consideration and approval of cease and desist orders. Are there any extractions or recusals on agenda item number 9? All right, seeing none, is there a motion on agenda item number 9?
I motion, Herod, that we consider the approval of the cease and desist orders.
Thank you, Ms.
Second,
Hurd. Is there a
Quinones.
second? Seconded by Dr. Quinones. Is there any further discussion? All those in favor of motion on agenda item number 9, please say aye.
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 All those opposed? Agenda item number 9 passes.
I see a hand raised. Ms. Morgan? Your hand is raised.
Her mic and camera were disabled. They should be set up right now.
Sorry about, okay, thank you.
Okay.
You should be able to unmute yourself now, Ms. Morgan. Can you, I'm so sorry about the earlier, we didn't see that it wasn't enabled. Are you
Right.
able to unmute yourself now?
Yeah.
There you go.
And Dr. Nyack was asking me, is he on?
Let's get that figured out.
He's on, his hands up also, yeah.
He has permissions now.
Okay.
All right, anything else? All good? All right, agenda item number 10, consideration approval of non-pro-tunc orders. There are none there. 11, consideration and approval of agreed resolution orders. There are none there. Number 12, consideration and approval of consent orders. There are none there. That brings us to agenda item number 13, which is consideration and approval of determination of default. We are after 8:10 a.m., so we can proceed on with that item. Go ahead.
Okay. May I proceed?
Yes, sir.
Good morning, board members. I'm Shane Neldner with the litigation division of the board. Board staff is here today to present a default order in the matter against James Thomas Jr., MD. This matter involves the respondent's inability to safely practice medicine due to a mental impairment. Board staff filed a complaint at SOA on March 5th, 2024. Despite board staff's efforts to obtain participation, respondent did not participate in the SOA process. On March 13th, board staff filed a notice of adjudicative hearing to be held on May 13th, 2024. A hearing took place on May 13th and respondent did not appear. A default dismissal order was entered by the administrative law judge on March 14th, 2024. Respondent did not file a motion to set aside the default. The ALJ issued a letter of remand on May 30th, 2024. On May 31st, board staff sent a notice to respondent's address of record that an order of default would be presented to the board on this date and time. Since then, board staff has attempted to call and email and mail, but all mail is returned as undeliverable. Respondent has not appeared at today's board meeting despite board staff's efforts, and therefore board staff would move that the board enter the default order that has been provided for your consideration. Thank you.
Sure. That response.
So before I
not
proceed on, is Dr. Thomas present?
Yeah. Right. Or counsel for Dr. Thomas.
Yes. Is Dr. Thomas or the counsel for Dr. Thomas present at all? And if you guys can just check and make sure that there's no hands that are raised. All right.
Not seeing
If
any
not-
pop up on Teams.
Okay. So if not, is there a motion on consideration and approval of determination of default for Dr. James Herman Thomas?
Quinones, go ahead and motion to approve the default as outlined.
Thank you, Dr.
Second,
Quinones.
Barnes.
Seconded by Ms. Barnes. Is there any discussion on this item? All right, all those in favor, please say aye.
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 All those opposed? All right, that item passes. The second determination of default is on Dr. Felicia Lenora Lewis. I guess I'll ask this question from right now. Is Dr. Lewis or counsel for Dr. Lewis present? All right, staff, you may go ahead and proceed.
Okay. This matter with Dr. Felicia Lenora Williams involves a respondent's failure to timely reply to a patient's follow-up request for information and failure to respond to board staff subpoenas and requests for information. Board staff filed a complaint on March 5th, 2024. Despite board staff's efforts to obtain participation, respondent did not participate in the SOA process. Board staff filed a notice of adjudicative hearing on April 11th, 2024 to be held on May 13th, 2024. A hearing did take place on May 13th and respondent did not appear. A default dismissal order was entered by the ALJ on May 15th, 2024. Respondent did not file a motion to set aside the default. The ALJ issued a letter of remand on May 31st, 2024. On May 31st, board staff sent a notice to respondent's address of record that an order of default will be presented to the board on this date and at this time. Since then, board staff has not heard anything from respondent, and respondent has not appeared at today's board meeting despite board staff's best efforts to gain contact. And for that reason, board staff would move that the board enter the default order that has been provided for your consideration.
Okay, thank you. And again, there is no indication that Dr. Thomas is present. Is that correct?
That is correct.
Lewis.
Okay. All right. So with that, is there a motion?
Maybe Dr. Lewis, Dr. Lewis or counsel for
Dr. Lewis, I'm sorry, Dr. Lewis. Is
Sorry.
there a motion on the determination of default on Dr. Lewis?
Yeah, this is Tibbles. I'll move we accept the determination of default on Dr. Lewis, item 13B.
Motion by Dr. Tibbles. Is there a second? Second by Dr. Bennerwide. Is there any discussion? All those in favor, please say aye.
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 All those opposed? All right, that passes. All right, the last one under agenda item number 13 is Dr. Reginald James Newsom. Is Dr. Newsom or counsel for Dr. Newsom present? All right, staff, you may go ahead and proceed.
Thank you, sir. This matter involves respondent's failure to meet the standard of care in chronic pain treatment of 16 patients when he non-individually prescribed high volumes of narcotics, benzodiazepines, without clinical indication, without monitoring for side effects, abuse, misuse, or diversion, and without establishing a physician-patient relationship, all through several clinics that he owned or operated throughout the Houston metropolitan area. He also aided and abetted the practice of medicine by a foreign medical school graduate who is not licensed to practice in Texas. And finally, he violated 2 board orders by refusing to undergo chart monitoring, K-STAR assessment, and pay a $5,000 penalty. Board staff filed a complaint on January 11th, 2024. Despite board staff's efforts to obtain participation from respondent, he did not participate in the SOA process. On March 28th, 2024, board staff filed a notice of adjudicative hearing to be held on May 13th, 2024, and sent that notice along with a copy of the complaint to a respondent's address of record. A hearing took place on 5/13/24 and respondent did not appear. A default dismissal order was entered by the ALJ on May 13th, 2024. Respondent did not file a motion to set aside the default. The ALJ issued a letter of remand on May 31st, 2024. On May 31st, 2024, board staff sent a notice to respondent's address of record that an order of default would be presented to the board on this date and time. Since then, board staff has emailed and called respondent and has heard nothing in response. Respondent has not appeared at today's board meeting despite board staff's efforts, and for that reason, board staff moves that the board enter the default order that has been provided for your consideration.
Okay, thank you, Mr. Neldner. And once again, I'm going to ask if Dr. Newsom or counsel for Dr. Newsom is present. All right, seeing none or seeing nobody there, is there a motion on that item?
Quinones, motion to enter the default order as outlined by staff.
Thank you, Dr. Quinones. Seconded by Dr. Martinez. Is there any further discussion? All those in favor, please say aye.
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 All those opposed? All right, item passes, and that concludes agenda item number 13. 14, consideration and approval of proposal for decision. There are no items there, which gets us to agenda item number 15, our executive director report. Mr. Carlton?
Yes, all right. Want to make sure, can everybody still hear me okay?
Yes, we can.
Yes.
Okay, great. Want to make sure there's not any long delay or anything. Well, it is good to see all of you. Good morning. I know you have a lot to go over still. It was a very long day for DPRC yesterday, and there's more items you guys have after this, so I'll try to keep this brief for you. For complaints against the agency, there are no new complaints against the agency since the last board meeting. As far as our audit, we do have dates for when the licensure department is going to go through their audit this year, and it's just the standard audit that we have every year that goes through and looks at different aspects of the agency. That's going to be July 15th to July 26th. And later this year, you will have the report and the findings or any recommendations that may come for that for your acceptance at a future meeting. For the rule update, you all should have received an email outlining where you can find the potential or the suggested draft language for rules for your consideration. As a reminder, as I'm sure you're all aware, since we've been talking about this for over a year, probably about a year and a half now, staff has been going through a complete review and rewrite of our rules. It's not just for the medical board, but for all the boards, the sub-boards as well. So you have those rules available to you. Because it is such an extensive rewrite, unfortunately, it did not really lend itself to doing a red line change where you could kind of track changes and see, where we changed language here and there as we went along. And that's because some chapters of the rule were completely eliminated and folded into others. And so we started out trying to do a track change, and it quickly became unworkable with the amount of shifting around that took place. But what we were looking for and trying to accomplish there was to modernize the rules, take into account things that have changed since the last time the rules have been done. Some of them, it's been many years, trying to remove any redundancy in the rules, anything that's just kind of restating statutory language. We're trying to kind of get away from that overall within the rules, and overall trying to reduce burdens and make things easier to understand for our licensees. So kind of the plan for this looking ahead is for you guys to have those rules available. You can start reviewing them now, and we'll take them up in the, I believe in the August board meeting, and we'll start looking at those. And hopefully, if you approve them to be adopted at the August board meeting, then they will come back to you in the October board meeting, or if there's any changes that need to take place, you'll have until the December board meeting also. But the goal is to have all of these rules, the new rules, adopted by the end of the year. And of course, it'll go through the same rule review and adoption process as we're going through the rule that we're going to discuss here later in the agenda, where it'll go out for comment and people will have their opportunity to give their feedback on whether or not they think the rules are like what they would like to see. And now I'll kind of go into our legislative update. Obviously, we have the session coming up for 2025. Staff is gearing up for that, and you'll hear a little bit more from Joey as we go through our budget update. We'll just kind of hit the high tops for you, and that way we can keep moving and see what questions you guys have. So Joey, I'll turn it over to you.
Thank you, Brent. Good morning, board members. So I'll be brief. Q3 just ended at the end of May. Budget execution is at 97%. Our revenue collections are just over 30 million, so we should be on track to exceed prior year revenue collections. As Brent discussed, we are wrapping up our legislative appropriations request that will be due sometime at the end of next month. Currently, we are receiving about 60% of the revenues we collect. So in our next LAR, we're asking to increase that to 90% with a focus on doing great things for employees, making sure that they get the salaries they deserve. So it should be a pretty similar ask to what we did last year. So pending any questions, I can hand it back to you, Brent.
Thank you, Joey. And as I said, we're looking at things to try to help reduce turnover. One of the biggest issues that we do have is we have, trained and skilled staff, and they sometimes get poached by other agencies or the private sector that are able to afford higher salaries for them. And so if we can address that for them, that is a high priority for us. And also one of the big asks that we're going to have in this upcoming session is a new software system to try to tie in our licensure and disciplinary, investigative, to get all these departments together into a single system. Because right now, again, our IT staff has been phenomenal over the years in keeping everything running with kind of home-built systems. But it'd be great if we could get to something that kind of integrates all of them, and staff do not have to kind of jump from one system to the next to try to find things. It just creates more delays for our licensees, either they're going through the application process or even through the disciplinary process. And an idea would be, if somebody tried to, if they wanted to file a complaint or look up a license, they could just start typing the name into a search bar, and it would start filling in the rest of the information for them as everything would be tied together. So ultimately, that would be something that is going to help out our licensees and the public as well. So trying to take care of the staff and really trying to make things a lot more modern for our licensees out there. Still, things that are on the table that we're working on through the rest of this biennium are going to be modernizing our TMB website. As we talked about before, it's been many years since it had a refresh, and so that's something that we are in the process of trying to get done here in the next about 14 months to the end of the biennium. So pending any of your any of your questions, that will complete my report.
Thank you, Brent. Any questions from the board members? All right.
Thank you.
And I know it's late in the afternoon over there. And again, I just want to once again thank you for your service. And for those of you who don't know, Mr. Carlton is on a mission with the Air Force overseas, and he's joining us virtually from over there. So he's been doing all this work as well as serving our country out there. Next item on the agenda is our medical director report. Dr. Brett.
Yes, morning, everyone. Finally got the technical detail camera and mic squared away, so I hope you're seeing and hearing me. We had for the approval of the experts, we had 8 experts preliminarily approved by DPRC, final approval for the minutes today. We do have some expert needs. By and large, the changes that have created a lot of the backlogs, in particular the primary care specialties. We actually are no longer soliciting experts for. We have a good supply at this point. We do need some specialists in pediatrics. Dr. Batio, a couple of pediatric cardiologists. We still need pediatric gastroenterologists and pediatric pulmonary experts, as well as some of the subspecialties in internal medicine, oncology, hematology, also in rheumatology and neurology. So if you have any recommendations for any of those experts, please forward them along to me, but I'll go ahead.
Great. Thank you, Dr. Brett. And just a reminder to everybody that those expert panelists are extremely important, especially in order for us to be able to facilitate the process of complaints. You know, if we don't have enough expert specialists in a certain specialty, that just delays the process. And you know, having that available is something that's important to make sure that things move forward in a timely fashion. All right, with that, I'm going to go ahead and proceed on to the public information update.
Good morning. I'm Tori Sloan. I'm the Director of Government Relations and Communications here at the TMB. I just have a couple of quick updates for everyone. I know Dr. Zafran mentioned CE Broker in his opening remarks, and that launched earlier this month for physicians. We're going to be rolling that out over the next year for all of our licensees. Licensees will start to see a lot of communications from us when their time comes up. So that's something you'll see on the website and by email being pushed out from us. Also, yesterday, there was a good discussion about the TMB workforce in the Finance Committee. I wanted to point something out to everyone. We just recently submitted our strategic plan for the FY25 through 29 fiscal years. And in there, there's an excellent workforce plan section. Thanks to Ms. Freeman and Ms. Moreno and a couple other people in the agency. It's very robust. If that's something that you're interested in reading about for the agency, there's a wealth of information in there. That's on the website. If you need help finding it, feel free to reach out to me. Last but not least, I wanted to introduce everyone to Mr. Spencer Miller Payne. He is our new communications officer here at the agency. You all know that if you receive inquiries about communications or the media, you know to either let Mr. Carlton know, Mr. Freshour know, myself. You can now also let Mr. Miller Payne know, and because he's going to end up being our primary liaison with the media from here on out. So I wanted to welcome him and let you all see his shining face.
Great. Thank you and welcome on board.
Thank you.
That's it.
Great. Any questions from the board members? Great, thank you. And I know that going toward the end of the year, you're going to get a lot busier, so look forward to it. All right, with that, we are going to go to the report from the Physician Assistant Liaison. I know that we have Clay Bowles and Dr. Ali on. Is there a report from you guys? Dr. Ali, if you're on, unmute your mic, and if you guys have a report from the PA board, we can. This is the time that we can present it.
So Zafran, we got PA Corbett's name, hand raise, I think is going to be given that.
Okay, all right. So I guess Ms. Corbett and the others are on there. So Ms. Corbett, go ahead and proceed.
Good morning. There are no updates from the PA board today.
Great, thank you. All right, we're moving fast from here. Next item is consideration and possible action regarding pending litigation. There are no items there. Report on temporary suspension hearings. These are all reports that you have available and that you can see. Report on suspensions by operation of law. Report on motions for hearing requests. There's none there. Report on cease and desist orders approved by executive director. That's in your file. Report on automatic orders. That's in your file. Report of cancellations regarding investigations. That is in your file. Consideration and approval of orders to show cause. There's none there. Consideration and approval of revised, vacated, or amended orders. There's none there. And with that, that brings us to agenda item number 28, which is consideration and possible action on rules regarding exceptions to the ban on abortions. Before I proceed on with this, I'm going to go ahead and read a statement to kind of help everyone understand exactly what we've done and how we've addressed this. As all of you know, we put out proposed rules back in March, and based on that, we elicited public comment for a period of time, and we had a good fair amount of robust public comment. We also had a stakeholder meeting where we spent quite a bit of time, several hours, where we had a good conversation with stakeholders on things that they felt were opportunities to improve, suggestions, and so forth. So with that, we have come up with, or staff has proposed to the board, its final recommendations for the board's consideration. Thanks to that robust feedback, these modifications to the proposed rule that we believe not only better capture the board's original intent, but also reduce any perceived burden on providers. As such, today the board is going to consider possible adoption of this rule, and I'm going to kind of highlight some of the specific changes that we made. I'm going to lay out the primary concerns the board received and address how and whether those concerns were ultimately addressed in the final rule. As many of you know, there are certain things that we can address, and there are certain things that we ultimately don't feel that we have the authority to address. First, the vast majority of comments requested changes to the various definitions in the proposed rule. Specifically, there were requests to expand definitions and include exceptions for rape and incest. However, as we have stated on multiple occasions, the board does not have the authority to unilaterally add any exceptions or expand any of these definitions, especially when they're statutory definitions. These actions specifically require legislative intervention. Commenters did, however, express their desire to see references to ectopic pregnancy in the rule better track with existing statutory references on the matter. In response, the board made revisions to include references to Chapter 74 of the Civil Practice and Remedies Code in sections 165.8 and 165.9. Another common request was for the board to clarify imminent risk of death to a patient is not required. In response, the board clarified in 165.8D that imminence of death or impairment of a major bodily function is not required. That is specifically in the rule that is proposed before you right now. Commenters also overwhelmingly raised concerns that Section 165.8 was increasing existing documentation requirements and placing an additional burden on physicians. Upon review, TMB staff decided to remove certain documentation language from this section and instead revise Section 165.9 to ensure that the rule was consistent with and correlates to existing documentation standards in the Medical Practice Act and Health and Safety Code. Additionally, with regard to documentation, the board did clarify that documentation must be completed within 7 days of the medical emergency and not necessarily before or at the time care is provided. I reiterated at the stakeholder meeting once and for all that essentially you do not have to stop your care in an emergent setting in order to document. And we specifically put a reasonable timeline of 7 days after an event where you can appropriately document in the medical record. Comments further revealed that there was near universal objection to the provision on whether there was adequate time to transfer a patient, and that this would cause a delay in care and create the impression that transfer is always required. In response, the board removed this provision and clarified that transfer issues are reviewed by the board's expert review panels in an emergency medical situation if it's applicable. Finally, a number of commenters asked for a list of medical conditions that would allow for an abortion. However, as I have previously stressed, because each patient and their presenting condition is unique, any list would be incomplete and not necessarily applicable to a given medical situation. And as I also mentioned, the problem and the conundrum is what if you have a situation, a condition that is not on that list? Then there's an implication, even though it may be inaccurate, that it's prohibited, and that may not be the case. Based on the comments, this is not just my opinion, but is a shared opinion amongst licensed providers and their professional associations who also did not agree with requests for a list or a checklist. The Texas Medical Board General Counsel has determined that none of the aforementioned changes are substantive because they do not increase any regulation or add new requirements on physicians. The edits merely clarify the board's internal proceedings and performance of duties related to complaints and investigations, and do not substantively control, forbid, preclude, or hinder reasonable medical judgment in response to a medical emergency. Therefore, it is the recommendation of the General Counsel to adopt the rule with these non-substantive revisions. And that is what is before you, board, right now. I know that you've had a chance to review the recommended changes, the recommended final proposed rule by staff. And this is the opportunity for the board specifically to ask questions and the opportunity to have discussion. So with that, board members, are there any questions or is there any discussion on the proposed final board rule? And I know that we have Mr. Freshour on board, and as we have stated, the recommendation is that since there are non-substantive changes and there is nothing in the changes that have been made that increase requirements or increase the burden on licensees, that it is appropriate for this to be voted on today by the board.
That's correct.
Again, I'm going to give a
Dr.
chance for
Zafran.
everybody. Mr. Freshour, do you want to comment on that?
No, I was going to say that's correct, Dr. Zafran. I am recommending that you consider adoption. If it is adopted, what will happen is that my staff will, if you vote that way, we'll file what's called an agency order adopting the rule. That will be filed with the Texas Register. It may be today, it may be the early part of next week, and then 20 days after that order is filed with the Secretary of State, the adopted rule would go into effect.
Great, thank you. Once again, any questions, discussion points by the board members? I know that this has been, sorry, go ahead, Ms. Morgan.
So on exceptions, specifically, they're still broad. The exceptions are broad. Is this still going to make a physician feel uncomfortable in treating a patient or cause hospitals to turn patients away?
That's a very good question, Ms. Morgan. I'm glad you asked that. Earlier I spoke about making sure that there is a firewall from anyone interfering in the physician-patient relationship and a physician's judgment in how they treat a patient. It is absolutely inappropriate for anyone other than a physician or an ethics committee that includes physicians from superseding the judgment of a physician in a specific circumstance. At the end of the day, ultimately speaking, we are going to hold a physician accountable to the standard of care. And what we've done here is we've outlined within the law itself and within the rules that are already in existence, what we feel and what we believe that standard of care is. As far as the comfort for physicians to act in an individual situation, all we can really do is highlight what the law states and how we as a medical board, when we receive complaints, how we would view it and how we would treat it. Now, as you know, there is nothing that prevents a prosecutor in an individual county or an individual who wants to file a lawsuit to do so. What I can tell you is that the Supreme Court did defer to the medical board to define what is an appropriate, reasonable medical judgment and what the exceptions are. So as such, my hope would be, and my strong recommendation would be, that any entities out there would defer to the actions of the medical board in its judgment when a complaint does come in as to whether something was appropriate or not. I think that would ultimately help provide some comfort in physicians applying the standard of care as they deal with issues like this. As I said earlier, there is no list of conditions that we can list out there that could cover every single circumstance that comes on. You can't have medical judgment and a list in the same sentence. It doesn't make any sense, because by definition, medical judgment means that you've got to look at the specific circumstance and make a judgment based on the exceptions as to whether something is appropriate or not. And there are consultants that one can consult, physician consultants in the field that they can ask for recommendations as to whether something is potentially going to create permanent harm or permanent injury, or substantive harm or substantive injury. What we did specifically highlight is that one does not need to wait until imminent harm is about to happen in order to act. And I can't emphasize that enough. In fact, even though the Supreme Court mentioned it, there was enough concern highlighted in the stakeholder meeting that we felt it was appropriate for us to actually specifically include it in the rule. So one of the things that we've heard earlier on concerns about was physicians feeling that they needed to act to save a patient's life, knowing that they may not be in immediate harm right there and then, but knowing very well from their medical judgment that a week later or a couple of weeks later, there would be imminent harm. There would be a potential for a patient to be septic and have a deadly infection or whatever it might be. And we've heard of instances where hospitals potentially may have superseded a physician's recommendation that a patient be admitted and have what they felt was the appropriate treatment. And what we're saying here very specifically is that there is no right for anyone other than a physician to make that judgment. To do so by anyone else would be practicing medicine without a license. And that is something that we want to hear about if it happens. As I said, it's appropriate to seek counsel, to seek advice, to seek consultation. But at the end of the day, it is the physician who is going to render that final recommendation and that judgment on how to act on a given scenario. And that given scenario is going to depend on that specific circumstance. As I said, there could be a similar circumstance or a similar type of condition. In one circumstance, the proper action may be one thing. In a different circumstance, it may be a different action. And that's why we were very careful about not listing specific conditions that we would feel would be an exception. We wanted to make sure that a physician had the opportunity to determine, based on the circumstance, based on the place, based on what was available or what may not be available, based on the circumstances regarding that specific patient, what the appropriate action would be. And again, if a complaint were to come, it would go to expert panelists who are physicians also in that field, who are practicing in that field in the state of Texas, licensed in the state of Texas, who would be opining on what the standard of care is based on the law and based on the rule. And that is no different from any other different way how we would apply what the standard of care is in any other circumstance. So again, to answer your question, we can't take away physicians' hesitation or reluctance or concerns or fear. We can't take away that fear of potential prosecution. But again, that goes with any other case today. What we can do is highlight as best we can what are the processes that we're going to follow in addressing complaints that come through. What are the specific areas in the statute that we are going to ask everybody to follow? What are the circumstances that we feel are appropriate? Again, the two very specific exceptions, which includes concerns about death or concerns about permanent injury or harm. Those are really the two lists. How you determine what those two specific lists are does not involve or include a list. That's where the medical judgment part comes in. And you cannot list something that involves medical judgment. Otherwise, we won't need to have expert panelists. We won't need to have somebody sit here and opine on whether medical judgment was appropriate or not. It would just be black and white. And as I said at the stakeholder meeting, what is black and white are the exceptions. What is gray is the medical judgment part. If it was easy, the Supreme Court would not have had to grapple with it. The courts in general would not have had to grapple with it. They would have not sent this to the medical board to explain how we would ask our licensees to render and use medical judgment. Again, if it was easy, we wouldn't be going through all this process. And again, I'll just repeat that for emphasis because I know that this has come up a lot. What is black and white are the exceptions. What is gray is the medical judgment. And that's why we're sitting here. Medical judgment as it pertains to any condition in medicine is gray. It depends on circumstance. It depends on place. It depends on time. It depends on who the practitioners are and who the experts that are there. Whether it's at a tertiary facility in the middle of Houston or whether it's out in rural Texas, that makes a difference. That's where judgment comes in. That's where you're going to have differences of circumstances that may give different renderings of what medical judgment is in that circumstance. And you can't dictate what that is. That's why we're physicians. That's why we have given ourselves the license to look at these circumstances and make a judgment to the best of our ability and to be able to move forward with that. So that's, I hope that answers your question. Dr. Quinones.
Yeah, I'd like to just comment on Ms. Morgan's point. You know, one of the as I look at this ruling and what impact it has on practice, I don't think there's absolutely anything that this board could do that would completely cover every single possible scenario under every single circumstance. But one of the things that, and correct me, Dr. Zafran, if I'm wrong, one of the things that this board is intensely trying to do is to protect the doctor-patient relationship and the ability of a physician to make a sound medical judgment. And this ruling is to outline the need for documentation and support of that sound medical judgment. But one of the holiest of holy things that we have is that doctor-patient relationship, and how we protect that relationship is important. This ruling is to, if I interpret it correctly, is to protect that relationship, that decision that that doctor makes with that patient and that patient's family at that very moment when somebody has to make a decision, somebody has to decide, somebody has to step beyond the line and try and save life or maintain quality of life. Somebody has to make that decision, and that's what we're trying to protect.
Yeah, you're absolutely right, Dr. Quinones. And, and I think from what we've heard, that is what we've heard from the public. That's what we've heard from patients. And that was the concern that we heard, that we are interfering with that physician-patient relationship. And I think what we're trying to do in this rule and what we're trying to highlight is that is a sacred relationship that has to be protected. And ultimately, the judgment that's going to come about is going to come about based on that relationship. Again, what's black and white is the conditions of permanent harm or permanent injury to the mother. You know, it's you know, we spent yesterday, how many hours, Dr. Quinones, for, you know, 7-8 hours looking at standard of care cases in general in many different arenas. And these are cases that have come before the board, that have gone to expert panelists. And even with that, we are sitting here and we are debating what was the appropriate and right thing to do, because there is no wrong or right answer. It's all shades of gray. And it's the same thing over here. And what we wanted to reemphasize is that process that we're going to be looking at. There are things, like I said, that are absolute. You know, we talked about ectopic pregnancy. We talked about, you know, imminence not being necessary. All these things are things that we wanted to lay out there very specifically. But beyond that, you really don't want to get in between that physician-patient relationship and the nuances that are involved there that are really, frankly, going to be different from one case to the other. And you just cannot list that out. It would be unfair to that physician-patient relationship to have some arbitrary list that tries to codify what may or may not be acceptable. And I'm sorry, but you know, you can't legislate that. It's very hard to legislate that component of it. It's very hard to you know, protect against that, frankly, because again, people can file lawsuits. Anybody can file a lawsuit about anything. I mean, frankly speaking, and I understand that in this case, it's very difficult for physicians to you know, to not take that into consideration because it is their livelihood. I understand that. I get it. As I said before, that's nothing I can control. That's nothing that this board can control. Again, the same thing with prosecutions. You know, the Medical Practice Act is a law, and anybody can, or any prosecutor in the state of Texas can prosecute under provisions of the Medical Practice Act. A lot of times, in many other instances, they defer to the medical board, and they look at the judgment of the medical board in opining what reasonable medical judgment is before they act on it. In many instances, we as a medical board refer cases that we feel need to be referred to law enforcement. And once again, I would hope, and I'm saying this again and again and again, I would hope that prosecutors in the state of Texas would defer to us and defer to possible times when we, as a medical board, may feel it's appropriate to refer to law enforcement. I think that would give everybody a sense of comfort. I can't mandate that. All I can do is I can strongly recommend it. And I can reiterate again what the Supreme Court said, that when it comes to medical judgment, defer to the medical board. If we are all going to follow that line of thinking, I'm hoping and I'm thinking that physicians will have some of that comfort level in doing what they do best, which is treating that patient in that circumstances with their appropriate medical judgment. Anyone else?
Well, my concern is about the patient in particular. I don't want to see any woman, you know, that is going for treatment and refuse treatment because of a physician that is afraid of consequences. And I just want to make sure that a pregnant woman is treated fairly and treated, you know, that they're having a miscarriage or whatever, and they're not turned away from medical treatment if something's going wrong. And I just want to make sure that they're covered by these rules and not turned away because of a physician or ER is afraid of a persecution.
Yeah,
Luann.
You know, just before I give you to Dr. Kuna, so remember that just like we can sanction a physician for rendering treatment that may be inappropriate, we can also sanction a physician for not rendering treatment when they appropriately should do so. And that is something that I want to emphasize, particularly, of course, in emergency rooms. You know, emergency rooms are a very particular place where laws apply, that your ability as a physician to choose not to treat is you don't have that flexibility in the emergency room. You have to manage and treat a patient who needs treatment, at least to the point of making sure that that person is stable and under any type of medical condition. But obviously, on a personal level, if a patient goes to an OBGYN in their private office, regardless of this type of case or not this type of case, I mean, a physician does have a right not to, or to choose not to accept that patient, especially if they haven't already established a physician-patient relationship. That's something that happens and that can occur with any type of condition right now. That's not specific to this type of condition. But if somebody's going to an emergency room and they need help, or even if they come to a physician's office and they are in dire condition and in need of help, even today, that physician is still responsible to make sure that that patient is stabilized, whether it means immediately calling 911 and sending him to the emergency room, or even if they have to stabilize the patient right there and then at the office. It's going to be hard for us to get physicians to a comfort level to where they can, right off the bat say, I'm not going to have concerns. Again, I think that's what we're trying to address over here. But once again, if a physician doesn't do what they're supposed to do, again, it's kind of the opposite of what we're saying here. If they don't do what they're supposed to do, that may also be a violation of the standard of care. So if a woman comes in and she has a miscarriage and it looks like she's about to be septic, in other words, have a bad infection, and a physician chooses not to do anything, that may potentially be a violation of the standard of care. And that's something that I think we need to emphasize also, is that not rendering care is potentially also something that is actionable by the medical board. Rendering care under the provisions that we've described, under the metrics that we're looking at, is something that, if it's emergent and a woman's life is in danger, it should be really a no-brainer. If there's a judgment call around it and they need to get consultation, more opinions, whatever that might be, obviously there may not be a degree of imminence there. And again, that's a judgment call by the physician. Then they can do so. But at the end of the day, they need to apply the standard of care. And if they feel that they can't, for whatever reason, it is still their responsibility to refer that patient to a physician who can take care of that patient, is willing to take care of that patient. You can't just fire a patient and say, I'm not going to take care of you. There's still responsibilities that treating physician has until the mother has somebody who is going to appropriately take care of them. And by the way, Ms. Morgan is a public member of the board. The board has 12 physician members and 7 public members. And that perspective of a public member of the board is incredibly important, because really, Ms. Morgan and other public members bring a perspective that is important beyond just us as physicians. And that's why we're able to have these debates and have these questions and have these conversations, discussions. And we're able to do so in a manner that I think helps the public as we help define these rules and help put them out there and clarify how they are going to be enacted. Dr. Quinones, you wanted to say something also?
Yes, and you covered exactly what I was going to say. I was going to remind Ms. Morgan that the opposite side of the coin is also something to consider, and that is that we hold physicians accountable not only for the actions that they take, but for the actions that they don't take. And that's very important to consider. The other thing, and you heard me say this yesterday when we were reviewing a case, I said one of the most powerful aspects of our healthcare delivery system is that patients have the right to vote with their feet. And if they find a physician that is uneasy or uncomfortable, he has the opportunity to send that patient to someone who can take care of that problem. It may be a very complex problem that I can't take care of, but I know who does, is the scenario I'm trying to create for you. So yes, there's no way that anything that we do is going to alleviate the apprehension or avoid the apprehension and the fear or the reservations that physicians have. But one of the things that we can do is hold sacred that physician-patient relationship, and how that physician interacts with that patient is always protected. As long as his reasoning is valid and well documented, that's what the ruling is for. We can't change how physicians feel. We can only let them know that that relationship is sacred and protected.
Thank you, Dr. Quinones.
Sorry for
Dr.
that.
Tibbles.
Yeah, just I want to avoid piling on to a lot of things that have been said. Just a couple of comments. It was probably never reasonable to think that a state agency was going to resolve and provide complete clarity on such a complicated issue. But I applaud the effort and think we landed in a really good place. I understand the appetite for a list. There's also a reason we don't have a list defining the standard of care across multiple conditions. Personally, don't want to ever see us try to legislate or rule make the standard of care. I think the standard of care is, one, ever changing, and two, to be defined by the medical community. And then I want to reiterate another point, the focus on the comments about we have authority to take action against inaction, not only against licensees, but against anyone else who is practicing medicine without a license, including entities. So this is a physician decision. And yes, we can take action against a licensee for not taking an action, and we could also take action against an entity who's directing inaction. So appreciate the efforts by staff putting together what I think is a good set of rules.
Thank you, Dr. Tibbles. Thank you, Dr. Tibbles. Dr. Naidu?
Yes, sir. A prudent physician judgment sometimes vary widely. And for example, a patient with moderate mitral regurgitation, the physician who is performing the abortion can say that it's going to hurt the patient. A cardiologist can say you can proceed with it. And how can we, where we put a line, or a chronic kidney disease, stage 3, it can get worse slightly, can reverse it. Where do we put a line, which is good judgment without an expert opinions?
Well, that's exactly why we have expert panelists who opine. That's why sometimes we have to go to 2 or 3 expert panelists who have to opine, because if we were going to assume that everybody's going to agree on what the absolute standard of care is, we sometimes, even within our own expert panelists, would not need more than one. What you're highlighting is that medical judgment is not black and white. That, again, it depends on the circumstance. I mean, when you talk about the fact that a physician may feel comfortable doing one thing, but the cardiologist may be comfortable proceeding on, that kind of highlights, again, what if there's not a cardiologist immediately available to help take care of that condition? And I'll use the example again of rural versus urban. There may be an infection that a mother's facing in a rural area that if you're in the middle of Houston or Dallas or San Antonio or Austin, that it may be appropriate to treat in a certain way, that those facilities and those capabilities may not be available out in a certain part of Texas. Whether it's the right antibiotic to be able to use, whether it's the correct monitoring area, resuscitating somebody who's in sepsis is obviously, as we all know, sometimes can be very difficult. Minutes can count, and the capabilities that you have in that instance may not be available everywhere. So what I have available in one area may render one medical judgment. What I have available in a different area may render a different medical judgment. Hence, as Dr. Tibbles mentioned, why you can't have a list, because the circumstance and who's available and who you have that can intervene may not be there. I mean, we talked about the ability to be able to transfer from one area to another, but again, as was noted in our stakeholder meeting, we did not want that to be a requirement, because There were those who may have felt that you couldn't transfer to a higher level of care in a manner that was going to be safe, and that you almost had to exclude the ability to be able to do that in order to proceed on and do something that needed to be done. So we took that out of there so that physicians didn't feel that that was a question that they had to answer before they proceeded on with doing what they felt was the right thing to do. So again, all the questions that you guys are asking are really good questions, but it's highlighting exactly why we're doing what we're doing. And again, let me just reiterate something that I said earlier on is the concern with a list is what if a situation arises when something is not on that list? There's going to be a perception out there that because it's not on the list, that means that it's precluded, when it may be something that's completely appropriate based on the circumstance and based on the medical judgment in that scenario. So there's a dangerous aspect of actually putting out a list, and that is the situation of something not being on the list. What are we going to wait until we have another rule change and we start adding more things onto the list as situations change? That's going to be harmful. And I think that we just got to be wary of doing what we think may sound easy, but actually in reality may cause more harm. We've got to trust the process. As hard as I understand that that sounds, because of, again, the anxiety on the provider side and the feeling on the patient side that they're still waiting through a certain amount of uncertainty. But there's a certain aspect of medicine that is uncertain. What's black and white, I'm reiterating it again, is that if a woman's life is in danger, there is no uncertainty there. If there is imminent harm, there is no uncertainty there. That is where action should happen quickly. And as much as we're going to try to help explain that, whether it's now or whether it's in the press release that we put out a little bit later on, or whether it's in how we define these processes as we start getting potential complaints and how we manage through that, it's going to be a work in progress. But this is what we can do within the limitations that we have, short of other legislation passing. So within the confines and the limitations of what we have, whether it be legislation or whether it be court rulings, which also can have an impact, we feel that this is the best we can do, giving that physician-patient relationship the most amount of flexibility and deference, with the guardrails still in place.
Is the patient will have a right. For example, there is a moderate risk. The physician thinks it's going to hurt the patient's life. Our patient thinks that I'll take the risk, proceed with it. Can she do that?
So, obviously a patient has to be able to raise whatever concerns they need to raise with the provider. As we've seen in many other cases, there are some providers that may respond to that better than others. And that's why I discussed earlier today, communication, empathy, all these things are extremely important as we look at any situation or any condition. In an emergency situation, there really shouldn't be an issue about that. It should be something that is acted on immediately. If it's not something that is imminent, as Dr. Quinones said earlier, you can vote with your feet. In other words, if we're not talking about imminent harm and a physician is not responding in a way that the patient feels is appropriate, then it is completely within their right, again, assuming that there's no imminence of danger there, that the patient seek another physician. And somebody who's going to be more responsive to that patient's specific needs. Any other questions or discussion?
And Dr. Zafran, you can call for a motion or something on this at this point if there's no more discussion from your board members.
Okay. I know that, Mr. President, I think we have to wait until public comment.
Yes, all comment. This is not an issue for public comment. This is a board vote now. Any comment that would be made related to this or anything you've done today or with our regular board meetings, Dr. Zafran will be at the public forum item when you get to that, sir.
Okay, Dr. Quinones, did you have?
I have a motion to make.
Okay, go ahead and make your motion.
Motion to accept the ruling as outlined by board staff and accept.
It would be a motion to adopt the rule that's proposed. Is that correct, Dr. Quinones?
That's correct.
Motion has been made by Dr. Quinones. Is there a second? Seconded by Dr. Seconded by Dr. Vanderwide and by Dr. Naidoo. I know we've already had discussion, but is there any discussion on the motion that's been made? All right, with that, all those in favor of the motion, please say aye.
Aye.
Aye. Aye. All those opposed, please say nay. All right, the rule is adopted as written. And Mr. Carlton or Mr. Freshour, can you just outline when and how this will be published and what the timeline or process is moving from here?
Yeah, I can do that. I'll do that, Dr. Zafran. What will happen is with this vote, the board staff in my office, Dr. Zafran, as I said, we will prepare an agency order adopting this. That will include a summary of many of the issues and the comments that you just covered. We will get your signature on that. Once that order is approved, my staff will then send it over to the Texas Register in the office of the Secretary of State. That may occur maybe today, more likely than that, early next week. And then once it's been on file with the Secretary of State at the Register for 20 days, the rule will go into effect.
Okay, thank you, Mr. Freshour. All right, so with that item, we're going to go to agenda item number 29. And actually, are there any other rules to consider now? I don't think so. Is that correct?
No. No.
Okay, so 29 through 35, there are no items for consideration at this meeting. With that, we will go to agenda item number 36, which is public comment. And I think that we have a signing list and we will go ahead and proceed from there. Do you want to manage this, Chris?
Yeah, if I can get the list we have. So everyone that is in the room right now, the people that are in the room, everybody signed in. No, not here for public comment, but I do understand that we do have an individual who, Mr. President, who would like to make a comment. The way this works is you can come up to the microphone, they'll start the timer, you get 3 minutes, and you can make your comment. Yeah.
If they are muted, they can raise their hand and we can unmute them and turn on their camera.
Got it. Now got it. Thanks. I appreciate it. I didn't expect you to allow me to speak before y'all voted, but I wanted to make sure that your board members knew that there is a concern with what you've done. Some of the things I'm wholly in support of, and they are coincidental with things that we, Amy Bresner and I, have recommended and talked about. We lost the list fight a long time ago. And so the repeated reference to lists, nobody wants lists. So we understand that. But here's what the Texas Supreme Court said in the Zarowski case. In an enforcement action under the Human Life Protection Act, the burden is the state's to prove that no reasonable physician would have concluded that the mother had a life-threatening physical condition that placed her at risk of death or of substantial impairment of a major bodily function unless the abortion was performed. Dr. Zafran, what you've just done is create a legislative history that says you're going to treat these cases just like your average garden variety standard of care case. That is not the burden in a garden variety standard of care case. And so you can't do that. What's going to happen here now is, because you haven't taken account of Zarowski, is complaints going to get filed. A physician's going to get hauled into the agency. They're going to think, because of the legislative history that you've established, that it's the old standard of care burden. If their lawyer's worth a damn, they're going to say, there's a different standard under Zarowski, and you're either going to dismiss that case, waste the agency's time and the physician's money, or you're going to go through it and you're going to get poured out at SOA. If you don't get poured out at SOA, you're going to get poured out in the district court. And meantime, that physician and all the physicians in the state are going to have been tortured because your rule does not change the burden of proof in a case alleging a violation of the prohibition on abortion in 171 of the Health and Safety Code. My wife and I made a recommendation last week for a rule that would have created a rebuttable presumption and then set out the criteria that the agency would have to prove all of in order to meet the Zarowski standard. I don't know if we were late with their comments or those will be taken into account. If they are taken into account, when the agency produces its reasonable justification based on the public comment periods for not accepting that, I expect that to be addressed. And if there's a way to address it outside of this venue, then I can commit to you that we will do our damnedest to address it, because these physicians have a right to that standard in Zarowski. The language is plain as day. And so it's not, you've created this legislative history. I do this. I deal with legislative histories, both at the agency level and the legislature. This is what we do. And you've just created a legislative history for something that's not right. This is not a garden variety standard of care case. When the physician doesn't provide the aid, that would come under the standard of care for a negligence case. And it's unfortunate this statutory language resembles a negligence charge, but that's not the standard. And the Supreme Court has set the standard. And if you didn't have time between Zarowski coming out and writing this rule today, then you should stop and take the time. That's why I wanted to speak in advance. Thank you for letting me go over.
Thank you.
Okay. Is there anybody else in the room that did not sign up that would like to make a public comment? Okay. So we do have several people who have joined the meeting via the Microsoft Teams link. If you are on the Teams link and you would like to make a public comment, you also can have 3 minutes to make your public comment. If you can either raise your hand or if you push *6, you can take yourself off mute. If there's more than one of you, we will figure out a way to get going in order here, but we will pause to see if anybody else. Okay, we do have some hands up.
Todd Ivy. Yes, Todd Ivy. I will, or he's unmuted, or you can unmute yourself, Mr. Ivy.
Okay. And Mr. Ivy, the same rules. If you have up to 3 minutes, the timer will start when you start speaking.
If you are on audio only, Mr. Ivy, *6 on your phone will unmute you. If you are on video, then use the toolbar, please.
My link is not letting me see who all has their hands up. Mr. Ivy, we can give you another few seconds here to see if you can take
Mr.
yourself off
Ivy,
mute.
you are now unmuted. If you can speak, I believe. No, you're muted still, Mr. Ivy. On the toolbar, there's a camera and a microphone. It looks like like a radio host or a recording studio microphone. If you can make sure that is not slashed through, that will unmute you. If you're on audio, again, press *6 on your phone.
We can give that a few more seconds. Is there anybody else that is on the Teams link? I don't see any other hands raised, but anyone else waiting to make a public comment? Okay, we can give Mr. Ivy another few seconds here to see. So if you'd like to disconnect from the meeting and rejoin, you can try that as well. We can pause for another moment here.
He did that, so clearly he can hear us. We just can't hear him.
Okay. While we're waiting, I can go ahead and just dispense with the, I think there's one or two more items on the agenda, and if he's able to rejoin, then we can move forward in that process. Again, if anybody who's out there wants to make a comment, please go ahead and raise your hand. I'll give an opportunity before I adjourn the meeting, but just go ahead and raise your hand from right now, and we'll try to give you that opportunity to be able to make a public comment. The next item on the agenda is discussion, recommendation, and possible action relating to personnel matters.
There are none, Dr. Zaffron.
There are none there. And are we ready for adopting the consent agenda items? Everything's on? Yep. Yeah.
Yes, sir. Licensure is there, I believe. Yes.
So, number one, consideration approval of the March 22nd, 2023 Medical Board meeting minutes and action items. Is there a motion to approve that item?
Motion to approve, DeStefano.
Motion's been made. Is there a second? Seconded by Ms. Barnes. Any further discussion? All those in favor, please say aye.
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 All those opposed? All right, and I see Mr. Ivy's back, but let me just go ahead and do the last one. Committee reports and consideration and approval of minutes and action items of committees meeting during the board meeting. Is there a motion on item number 2?
Motion to approve, Quinones.
Motion approved by Dr. Quinones. Is there a second?
Second, Harrod.
All right, Ms. Harrod, all those in favor, please say aye.
Aye.
All those opposed? All right. Going back to Mr. Ivy, are you able to unmute yourself now?
You need to unslash the microphone so that we can hear you. I know that you can hear us, but you need to unslash the microphone. Or if
And
you are
there's
on
a,
audio, yes, there's another one.
Yeah,
B
so
Moorhead.
if the other one, Moorhead can unmute, we can do that one while the other one is trying. Mr. Moorhead, are you able to unmute?
Yeah, I just unmuted. I'm just here to say that Dr. Ivy is really having trouble unmuting.
Okay.
So I texted with him. He's really trying. So maybe give him one more second. And let me text and see
Is
if I
he
can-
on audio only, Miss Moorhead?
I'm checking. But I don't have a comment, but I'm just telling you, I'm texting with him and I'm gonna try to help him.
Okay,
He is
yeah, I've
not-
instructed him
He's
to.
not on audio. Sorry, I'm sorry. He's not on audio only. He is on a computer. So give me just a minute and I'm gonna try to help him, okay?
Great, thank you.
All right, if somebody wants to tell Mr. Ivy that he may be able to call into the number as opposed to doing it through the computer, this may make it faster. Again, it's still relatively early, so I'm giving him a little bit of time. Just as we're waiting, I'll just, in general, I'll also say that, rules are rules. And as you are seeing with a lot of the other proposed rules that we're going to be looking at in the next meeting, these are things that obviously can be revised and adjusted depending on changes in circumstance, depending on what may or may not happen. That as opposed to legislation, it's relatively easier to change a rule. It's not easy, but it's relatively easier to change a rule as opposed to changing legislation. And so, those possibilities are always there. The interpretation of our council as it stands right now is that what we have right now is appropriate, but, that doesn't mean that we're right. Just again, like we talked about medical judgment, legal judgment can differ. And if that's the case, then we can obviously revisit at an appropriate time. So, Ms. Moorhead, I see that you're on now.
Oops, sorry. Yeah, I'm just to give you an update so you know what's going on. I think maybe he's going to try calling in.
Good. Okay, I think I'm going to give it until 10:30, which is 2 minutes from now, just in the interest of time and holding everybody up. Obviously, I think public comments can also be entered on our website, I believe, if need be, I think. But
Well, Dr. Zafran, at this point, yes, what we will do is, because the rule has been now adopted at the end of the board meeting, with the exception of Dr. Ivy, because he wanted to put in the comments, the comment section will be closed because the rule has now been adopted by y'all. So the comment period will close. We let the comment period go right up until literally Mr. Breslin's comments just a few moments ago, as well as Dr. Ivy, and then we will stop the accepting comments today because the board has taken its final action.
yeah, I was also kind of talking about public comments in general. It doesn't have to be about.
Yes, sir. Yeah. Yes, sir. Yes, sir. And we've been taking them all the way up along until literally last night we were taking comments, and it's been open on our website just as it was laid out when you and this board proposed the rule, and we had the comment form as well as the drop address.
Yep. All right, Ms. Moorhead.
Yeah, he's trying to call my cell, and I'm going to hold my cell up to the computer. Will that work?
Sure.
Okay, hold on a sec. We're working on it. Hang on. Okay, I'm calling him.
Hey, can you hear me?
Yes, we
Yes.
can.
Go for it.
Okay, first of all, Dr. Zephyrin, I want to thank you and I want to thank all the board members for really working on this. I know it's very complicated. It's a very complex issue. And we really do appreciate the time that y'all spent to help address this. I do agree. I want to thank Ms. Morgan for raising those concerns. I think it's very important to have public members and their input on this particular subject. I do want to acknowledge what Dr. Quinones said and how he realized that there's not much that the board's going to be able to do to relieve physician concern over this topic. But I do want you to understand I'm a practicing OBGYN in the state of Texas. I've been here for 30 years. And I do want to express that we do appreciate y'all trying to help us in this issue.
Thank you, Dr. Wright. Go ahead. Sorry, go ahead.
I was doing everything that everyone asked me to do, but it would not let me unmute.
I understand. Trust me, we've been having, yes, it's just a sign of the times. This virtual environment is not without hiccups, but thank you for trying, and I'm glad you're able to get your comments in, and I appreciate you and your colleagues in the profession understanding that we are trying to do the best we can. We're not perfect. That's why this is a process. Yes, we've issued a final rule, but like I said, again, final rules can be adjusted, revised, depending on circumstances that may come up. Now, I will tell you, are you still trying to talk?
No, sir, I'm not.
Okay, there's a little bit of an echo. I think that's why. You know, we did have the Supreme Court ruling before we actually did the revised rules. Like I said, I think it was reviewed, it was looked at. It was still felt that the way we've had it proposed and adopted is appropriate. But again, that obviously can be challenged. It can be something that we can be asked to look at and change again later on. That process is always open and available. This is what we have now, though, for right now. And as I said in my messaging, and I think you've heard in the discussion with the other board members, we recognize and we understand and we appreciate the concerns that are still out there from both the physician community side and from the public side. There's nothing that we can do to make this perfect. What we can try to do is highlight and explain the process as best we can, work through the process as best we can. I will continue to make myself available to the public and to the media to help explain our perspective of things as best we can also. You know, I've tried to make myself as available as possible. I know that this is not easy. It's not been easy for us. You know, but it's something that we've been charged to do, and hopefully we've been able to do the best we can. I can assure you that this has been deliberated, looked at by staff for many, many months. You know, we as board members have, as you can see, discussed it and talked about it here as best we can. We've tried to take as much input from our stakeholders as best we can, both in the written public comment and in the virtual public comment period that we held. I hope that everybody can see that we've made specific changes as a reaction to those comments where we can. I mean, obviously, like we said, there are areas where we don't feel we have the authority to make the kind of changes that were suggested. So we are where we are right now. We will work with what we have until we're told not to. Trust the process. We will try to make it as best we can work. We will try to highlight it as best we can, and we'll move forward. Brent, if you're still on, do you have any other comments?
No, Dr. Zafran, you've covered it. you know, we've worked really hard to try to come up with the best that we can with the circumstances and the way things are and the law and the court opinions. And there's a lot out there as well. And so, you know, again, this rule is not meant to be all encompassing of every single thing that's out there for statute and court opinions. It's just trying to highlight kind of how the board is going to look at some of this stuff. And then we'll kind of take it from there. But again, I appreciate the board's attention to this, and again, understanding that it's not going to make everybody happy, but we are trying to do the best that we can with what we got.
Great, thank you, Mr. Carlton. With that, I will entertain a motion to adjourn.
I motion that we adjourn, Harrod.
Thank you, Ms. Harrod. Is there a second?
Second, Naidu.
Seconded by Dr. Naidu. And is there any robust discussion on adjourning? Seeing none, all those in favor, please say aye.
Aye.
We are adjourned at 10:36 a.m. on June 21st, 2024. Thank you, everyone. Thank you for your work, board members, and I look forward to seeing you again in August.
Have a great weekend.
Bye. Thank you.
Yeah.
Bye-bye.